So, your workers' compensation case has been denied by the workers' compensation insurance company. And this means that at some point, you're probably going to hearing on your claim. So, maybe you've got private health insurance, so you've been treating with some doctors under your private health insurance for your work injuries. Maybe you've even had surgery for your work injuries. You're also not getting any income, not getting any weekly checks because your workers' comp insurance company has denied your claim. Your hearing date might be 4 or 5 months down the road, maybe 4 months or so down the road. And there really isn't any way in a denied claim to speed things up, unfortunately. But now you hear suddenly that the other side is interested in trying to make a settlement offer in your case. What should you do? I'm Joe Miller, workers' compensation attorney here in Virginia, North Carolina, and that's what we're going to discuss today. We had another video where we've done settlements and settlement offers in accepted claims or awarded claims, and here we're going to be talking about settlements in denied claims. There's a lot of workers' compensation lawyers that would never make a video like this. It gives a true picture of reality that they don't really want you to see. A lot of these attorneys want you to believe that they're going to get involved and wave some kind of magic wand, and as soon as they get involved, your case is going to settle beautifully and everything's going to fall into place and like magic. And I'm going to say that from time to time, especially in an accepted claim, when a lawyer gets involved, things sometimes do move faster and things do get resolved quicker because they know, okay, now they're dealing with somebody that knows the law and maybe we can be talking the same language and get things done. But here we're talking about a denied claim. What do we mean by a denied claim? Just make sure we're clear. It means that the insurance company believes that they've got some kind of defense or defenses to your claim that they appear to believe that they can win. In other words, show the deputy commissioner that you don't have a compensable claim at all, or maybe that, okay, maybe you have a compensable claim, but there's something going on that's going to prevent the claim from being held to be compensable. There's an obvious question that comes up in a denied claim. If they believe that they have a good defense or defenses, why would they offer any money at all? And the answer is because they're assessing basically their chances of winning, their chances of losing, and based on that, they're willing to make an offer before hearing. Sometimes when you get an attorney involved that they see and knows what they're doing and they know my reputation or what have you, they know that attorney's reputation, now they're going to be looking and say, okay, this guy was by himself before, now he's got counsel that knows what's going on, maybe we should consider making an offer. So should you settle before hearing? Every single case has to be evaluated on an individual basis. Is there a solid case that you suffered a compensable injury at all? If they're able to prove that you were injured through no risk of employment at all, let's just say walking across a regular floor with no defects, was not slippery, etc., and you slipped or tripped over your feet and fell, there's no risk of employment. Same thing going down a perfectly normal set of stairs, no risk of employment, you lose. A similar situation in North Carolina, different issue, but a similar situation. North Carolina requires to have an injury by accident. I have a video on this also. If you have an injury by accident, then that means that you have to have some type of slip, trip, or fall. Virginia does not require that necessarily. But in North Carolina, unless you have a back injury or spine injury in your neck, you must show some type of slip, trip, or fall. And if you don't have that, you don't have a case. So those are two examples of having a non-compensable claim, meaning it's a non-starter from the get-go. And if those are the facts, you're probably not going to win at all, and they may not even make any offer, depending on what's going on. And maybe you have some witnesses that say otherwise, maybe you say otherwise. That's the next thing. Do you have witnesses that support your version of the facts, which says, no, there was a defect in whatever I fell on, or I did have a slip, trip, or fall, or whatever it is that they're contesting. Do you have witnesses that are supporting you in that regard? And are they good witnesses, and are they going to help you? Okay, that's one factor. What about your doctors? Are your doctors supportive that, for instance, your injuries are actually from this accident, or maybe they're not from the accident, they were pre-existing? What do your doctors say? Are they willing to say the magic words to prove your case? The main thing is what are the chances of us beating those defenses? So you have to sort of assess your chances going into the hearing. If the chances are 50-50, you got a 50-50 shot of winning or losing, and they're offering some money, depending on your financial situation. If you're in a rough situation, you may have no choice but to start negotiating with them to try to get some money out of it and walk away and go on to the next thing. There are other practical considerations. How severe are your injuries? Do you absolutely have to have these folks treat you, for your injuries, or do you have some health insurance that down the line maybe you can use to treat later? I mean, these are just a few considerations. But what if the chances are better? Your attorney tells you, look, I think we got an 80-90% chance of winning this case. Their defenses are really junk, not looking too good. And, should you just then say, we'll see you in court? It's important you understand a couple of practical considerations that are in workers' comp that are not really in other kinds of cases. The first obvious thing is if the claim is denied, that means, as I've said before, you've gone a long time without any income. You've got to wait until hearing to have this heard. The second thing, at the end of the hearing, it's not like what you see on TV where, the judge says, Mr. Foreman, would you read the verdict, please? The foreman of the jury comes out. We, the jury, find for the plaintiff for the amount of verdict for the plaintiff for the amount of X amount of dollars. That's not what happens in a workers' compensation claim. At a hearing, what happens at the end of a hearing is nothing. It could be as much as 4 to 6 months before you ever get a ruling from the deputy commissioner. That's the sad fact. Once the opinion comes down, let's assume it's in your favor, the defense has a right to appeal. And potentially that goes to 2 levels. In Virginia in particular, you've got the Court of Appeals, and you also have the Virginia Supreme Court. After the hearing, you're looking at a year time to get this whole thing to work through the system. And what's going on all this time? You're not getting any income at all. As a practical consideration, I will tell you that when you do win, you're in a much better bargaining position than you were before the hearing, because now you have won. You have an opinion that says that you're entitled to benefits. So, now they have to pay their attorneys to go through that whole process, write briefs, etc. It's costing them money. So their calculation, the defense's calculation on their side is also going to change a little bit. So there are many advantages of going to hearing if you have a good claim and if you can financially afford it. You've got no income coming in. How are you going to wait another year after hearing before you get any money? Of course, there's another option we haven't discussed, all right? And that is some folks just go out and they get a job within their light duty restrictions on their own. The downside of that is it ruins your bargaining power, because one of the things they're scared about is being obligated for that potential almost 10 years of benefits into the future. Once you get a job at or near your pre-injury wage rate, okay, you've wiped that out. You would still have in that circumstance, even if you went back to work, your future medical. And if you have, let's say, an injury to one of your limbs, you may be entitled to a little more money based on that. But that's a much smaller case than going ahead and trying to claim, looking at potentially 10 years of benefits going into the future. So that's the downside of going back to work while the whole thing is pending. But listen, I totally understand. I've had clients that say, look, Joe, I would love to stick this out. I can't. I have a family to support. I got to go get a job. I totally understand that that's the way it rolls sometimes. But we can still negotiate some type of settlement under those circumstances. So I hope I've explained some of the scenarios that come up in a denied claim as you're approaching hearing and why you might want to consider a settlement, other practical considerations that you might want to take into account. If you or a loved one have been injured at work in Virginia, North Carolina, please don't hesitate to give us a call. Happy to talk to you. I'm Joe Miller. Have a blessed day. Joe Miller out.